Greetings and welcome back. In the last lecture, I talked about how the distinction between obscenity and pornography has historically been very, very elusive. It's very subjective. Individuals vary dramatically. And yet, from 1957 until 1973, the U.S. Supreme Court attempted to come up with a national standard for obscenity. They were really unable to do this. The Supreme Court had, in essence, had a double standard regarding this material. You may remember that Chief Justice Warren made this distinguishment between normal sex and deviant sex, and in this particular case, Warren did in the Roth case, Roth versus the U.S., ruled that obscenity was not protected by the First Amendment. However, to be obscene, material had to be utterly without redeeming social value or importance. The Warren court also, in the Stanley case, ruled that the private possession of pornography was constitutionally protected. And to me, the most important part of that case is that it helped establish an implied right to privacy that we'll talk about later in civil rights. In 1969, we got a new Chief Justice Berger, and Chief Justice Berger eventually came to the conclusion in the early 1970s that the Supreme Court was probably trying to do the undefinable and trying to set up a national standard for obscenity. So in the third case in your notes, Miller versus California, I believe that this is the most famous of all Supreme Court cases involving pornography. Miller versus California is still a landmark case. It is usually the starting point. It is usually the place that Supreme Court cases, even after 2010, 2015, they're still citing this case. And the Supreme Court did a couple of things in this case that are really significant. The most important of these things is that the Supreme Court ruled that community standards can define obscenity. It was an acknowledgement by the Supreme Court that we live in a very large and very diverse country, and that community standards are going to vary widely from community to community. And essentially, this was an acknowledgement by the court that they really could not come up with a national standard for what was obscene. The second thing that I find really intriguing about this Supreme Court case is that Chief Justice Berger changed the standard. And by that, remember, under Warren, to be obscene, material had to be utterly without redeeming social value or importance. In this case, the Supreme Court ruled that communities could ban or censor materials unless they had serious value attached. And of course, if material had serious value attached, it could be banned, it could be censored, it could be restricted. And so you have a couple of very important questions that come out of this. First of all, if material is protected, if it has serious value attached, the first and most important question is, well, who gets to determine whether or not material has serious value? And the answer in this case is, well, if it's community standards, well, then a jury at the local level would determine the question of serious value. And in order to give some instruction and some advice and some insight to help the states and to help communities determine whether or not material was in fact obscene or not, the court ruled that serious value could take place in more than one venue or more than one avenue. For example, if material had serious literary value, it was protected by the First Amendment. If it had serious artistic value, it was protected by the First Amendment. If it had serious political value, it was protected by the First Amendment. Or if it had serious scientific value, it was protected by the First Amendment. So material would be protected if it had serious value in any one of the four areas: literary, artistic, political, or scientific. And there was a challenge that was very famous, that Playboy magazine was being censored in, I believe, Charlottesville, Virginia. And the magazine claimed that it had value in all four of these areas. And the courts agreed in this particular case. There have been other areas where community standards have been upheld, and upheld more than once. For example, when it has come to the arena of nude dancing, and I talked a little bit about this issue earlier, but the state of Indiana wanted to ban, censor, and restrict nude dancing. The state passed a law mandating that dancers wear at least pasties and a G-string. The dancers sued, claiming that the state law was overly restrictive, that it interrupted the free exchange of ideas between consenting adults, and in a very, very narrow 5-4 decision, the U.S. Supreme Court in 1991, and you may want to write this down next to Miller versus California out in the margin, that in the nude dancing case, the Supreme Court ruled that Indiana, by a narrow margin, 5-4, could ban nude dancing. A few years later, the state of Pennsylvania was also hauled into court, and by that same 5-4 margin, the U.S. Supreme Court ruled that the state of Pennsylvania could ban nude dancing. So the arena of nude dancing is the most famous arena in which community standards have been upheld by the Supreme Court after the landmark Miller ruling. But in many cases, community standards have been defeated, and a good example of this would be the case that is mentioned in your notes, Jenkins versus Georgia. The primary issue in the Jenkins case was this notion of how much power do local juries have in determining what is obscene. This case came from a small town, Albany, Georgia. Local authorities in this case arrested a local theater manager that was showing an R-rated movie. This is a movie that you can get on Netflix. The movie is called Carnal Knowledge. This is a movie with a big-time cast. Jack Nicholson was the star of this movie. Art Garfunkel was a co-star. Rita Moreno was in this movie. Candice Bergen was in this movie. Anne Margaret was in this movie. So this movie had nudity in it, but there were no depictions of sexuality at all. And yet the local jury determined that this was a dirty movie. This was an obscene movie. The producers of the movie theater and the Hollywood producers said that this is a big-time Hollywood cast. This movie has been nominated for multiple awards. Georgia contended that in Hollywood, this movie in California might have serious value, but in rural Georgia, this movie is obscene. This case went all the way to the Supreme Court, and by a 9-0 margin, so it was unanimous, by 9-0, the Supreme Court disagreed with the local jury. They said that this movie had both serious and literary and artistic value, that in this particular case, this movie was not obscene. I don't even believe that this court believed that the movie was pornographic, let alone obscene. And of most significance in this particular case, the Supreme Court ruled that local juries do not have unlimited discretion in deciding what is obscene. To me, the significance of the Jenkins case is that the Supreme Court for 16 years tried to determine what was obscene. They were unable to do it. The Supreme Court in Miller said, we want communities to try to define this material. Now you have a local jury in Georgia that attempts to do this, and now the Supreme Court rules that the local jury was wrong. And so we're back to that big question. In this case, what constitutes serious value? Was the fact that this movie was nominated for an Academy Award, did this give the movie inherent serious value? The court seemed to think so, others might not. The Berger Court also established a very definite standard, and I think one that no one would disagree with. Scroll down to number 5 in your notes, Ferber versus New York. Mr. Ferber was a child pornographer, and in this particular case attempted to assert that his work was artistic. The Supreme Court disagreed. The Supreme Court ruled that child pornography is obscene and it is not protected by the First Amendment. The reason that the Supreme Court gave for this was that the state of New York has a compelling state interest in preventing the exploitation of children. While I think all of us would agree with the reasoning in Ferber, the obvious question is that the only reason for banning this material? Because if the only reason for banning this material is preventing children from being exploited, we have a potential problem. As technology has improved, now child pornographers can make computer-generated images that appear to be children. These are called virtual child pornography. But they're not an actual child. They're just the fantasy of the computer designer. So are these computer-generated images protected by the First Amendment or not? The Supreme Court, in a decision that surprised many people, and I will admit that I was a little bit surprised by this. If you scroll down to the bottom of your page and look at the case of Ashcroft versus Free Speech Coalition, the Supreme Court was asked to rule on a federal law that was called the Child Pornography Prevention Act. It was passed in 1996. The Supreme Court in this particular case ruled that the law was overly broad, it was unconstitutional, and that it abridged fundamental speech rights. In this particular case, the significance of the Ashcroft case was that virtual child pornography is protected by the First Amendment. This was a 6-3 decision by the court, and Sandra Day O'Connor, who was known as a conservative, in this case legitimized the court decision in the following way. She said, I was involved in the Ferber case, and in the Ferber case, we, the Supreme Court, banned child pornography because we believed that there was an overriding state interest in preventing the exploitation of children. We would never allow these children to be exploited by this child pornographer, Mr. Ferber. However, in the case of Ashcroft versus Free Speech Coalition, there is no actual child involved at all. These are fantasies of the computer designer. And since there is no actual child involved, there is no actual crime. And if there is no actual crime, then this law prohibiting this activity is overly broad, it's vague, and it's unconstitutional. And so there is a kind of a double standard in this case. Actual children involved in pornographic works, that's illegal, that's obscene. Those people go to prison, and they should go to prison. The Ashcroft case is a lot murkier. Certainly, you want to see children being protected by the courts. But the question in this case is that the only reason why we want to ban this activity? Some would argue this activity is inherently uh, dangerous.